Hi, everyone. My name is Robert Perkins. I'm the Director of Sales for Option City, and I'm based out of London. I'm joined here today by Lance Zinman, Sanjay Mehta, and Neil Robson from Cat & Mooch and Roseman LLP. First of all, I wanted to start out by thanking everybody that is able to join us today for the webinar. And I also want to mention that if anybody wanted to go back and view the contents of the webinar again, it will be available on our website, optioncity.com. And again, I also want to say thank you to the panelists for joining us. You know, this is obviously something that's going to be very important for our client base. And it's something that Option City has been working on for a good portion of the years, making sure that we are going to be compliant with MiFID II from our end. So we actually recently put out a document with all the changes that we're going to be implementing from our side. I just wanted to say that obviously this document will be available to all of our clients. But if anyone that's listening would like to set up a meeting or reach out to get a better idea of what we're doing to make sure we are compliant, you can reach out to us at info@optioncity.com or go to our website, optioncity.com, and we can set up a direct caller meeting. And the same goes for anybody that would like to speak with Lance, Sanjay, or Neil about the contents of the webinar from today. So at this point, I'm going to hand it over to Lance Zinman and begin discussing the regulatory and tax issues of the proprietary for proprietary traders related to MiFID II and Brexit.
Great, thanks, Rob. So thank you, everyone, for attending. I'm Lance Zinman. I'm the global co-chair of Catton's financial services practice. Cat & Mooch is a full-service law firm with roughly 650 lawyers spread across the U.S., particularly Chicago, New York, Washington, D.C., as well as in London and Shanghai. Our practice, although full service, focuses principally on financial services and in particular on hedge funds and proprietary trading firms. We do represent a number of the large proprietary trading firms in the world, and so this is a particular area of focus to us, which unfortunately means MiFID II has become a particular area of focus for us. Today we'll be discussing the responses to Brexit and the implementation of MiFID II from the perspective of proprietary trading firms that currently trade or are seeking to trade on European markets. There's a lot in play here and a lot of open questions that have not yet been resolved. Many of our clients are still considering, although at this point have chosen where to register if they've determined that they need to register under MiFID II in various jurisdictions. And so one of our potential structures has been to register in the UK, which has been a fair amount of our clients registering there. That obviously comes with it the uncertainty of what that means come Brexit and whether passporting will be applicable. Others have decided that they would not or they would not like to deal with that uncertainty, have determined to register on the continent. We'll talk about where, but really the finalists appeared to be the Netherlands and Ireland, and it looks like for various reasons we'll discuss that Netherlands seems to have gotten the bulk of the registrations. So that's a background. Giving a little bit of a further regulatory background on why we're here and the experience with the setup is, on May 15, 2013, while MiFID II was still being proposed in the EU, the German HFT Act, or the German Act on the Prevention of Risk Related to and the Abuse of High-Frequency Trading, went into force, introducing new requirements for high-frequency trading firms. In order to comply, a large number of firms, many U.S.-based as well, set up offices in London, registered with the FCA in order to passport into Germany. So that was the first instance of proprietary trading firms that otherwise weren't required to be regulated, registering in order to passport into Germany. For some times, other prop firms have been preparing to register under MiFID II, and as most of you know, MiFID II requires firms to be registered and regulated by an EU member state in order to conduct certain activities. And specifically, MiFID II require prop firms to be registered if they're members of or have actually DEA to an EU trading venue. They trade using an algorithm a high-frequency basis on an EU trading venue, or they are market makers, whether holding out or trading like one, on an EU trading venue. There are only a very limited number of MiFID II exemptions and exclusions that are available. One which we'll discuss is a recent development from German BaFin's proposal to allow third country firms to continue to operate on Eurex without an EU branch during a transitional period. However, depending on a number of factors, this may allow firms to delay moving their Eurex trading to European entities. Again, we'll go into that in a little more detail. Many other firms have decided to continue, especially those based in the UK, and register with the FCA and passport throughout Europe. However, as we all recall, on June 23rd, voters in the UK voted on a referendum to leave the EU, beginning the process of Brexit. And on March 28th of this year, Theresa May invoked Article 50 in order to formally start the process for Brexit. Again, as I mentioned earlier, although Brexit is intended to be completed by April 30, 2019, it's possible that we won't know much of the details until, quite frankly, the deadline to determine whether to remain in London or go to the continent has passed. And so that lack of clarity on negotiations, I think, will lead us to make a determination as to where the next viable country is, if ultimately people believe they'll need to move quickly out of the UK for MiFID II. So that is a bit of a background. I'm going to turn it over to Neil Robson to discuss the current state of play with Brexit and the impact that has on MiFID II registration.
Sure. Thank you, Lance. Hi, I'm Neil Robson. I'm a partner here in Captain's London office. So as Lance has just been saying, the threshold issues for prop trading firms are you a member or participant in an EU-regulated market? So that's your obvious ones like the stock exchange or Euronext, but also an MTF in Europe or a new trading venue called an organized trading facility, OTF, which will only come into existence after the 3rd of January when MiFID II takes effect. As Lance said, also DEA, direct electronic access into a European trading venue. Now, that is a definition that's been evolving. Whilst MiFID II and MiFIR, the regulation that goes with MiFID II, gave their specific definition, the market has been developing the concept as to exactly what that means. And what it comes down to is, ultimately, do you as a firm have the ability to use another member's trading code to input your orders straight into the trading venue's order book at your own discretion? Or is it intermediated in some way, either by the member whose trading code you're using or by a broker, for example? Only where it's direct and in your hands would it be deemed to be DEA. That's the current thinking. So intermediated access to a market, trading through a broker, sponsored access, there are different methodologies which might mean that you could be out of scope of that particular requirement. High-frequency algorithmic trading, or HFAT, that is a very specific requirement. If you are in the EU or you are elsewhere in the world trading on a high-frequency basis, using an algorithm, using software and technology designed to reduce or minimize latencies, then you're again likely to be in scope and need to be registered. Now, high-frequency here effectively means 2 messages per second over the course of a trading month in a particular instrument admitted to trading on an EU trading venue, or 4 messages per second with respect to all instruments traded on any particular EU trading venue. So it's pretty fast, although Lance and I often joke that frequently somebody's got a fast finger, they might get a screen trade at that sort of speed, but it does focus in on there has to be an algorithm involved. And then when it comes to market making, there's different interpretations as to whether or not a firm is or is not market making. As Lance said earlier, either you're within the specific scope or you might be holding yourself out as a market maker. And the specific scope is you're basically sitting on the bid ask for 50% of the trading hours of each particular EU trading venue during a particular trading day. That would be likely to start catapulting you into scope of the market making requirement. as Lance said, there are some exemptions in the EU. We'll gloss over those for the purposes of this session on the basis that we're assuming you do need to be registered and authorized for MiFID II purposes. And as Lance said, actually, Brexit does throw a spanner in the works to a certain degree. I'll move on to that in a second, but the exclusions that Lance referenced a few moments back, these only apply to non-EU persons. So specifically, to use the phraseology that in the MiFID II directive and the regulation, third countries, persons who are outside the EU. If you're already in the EU, this piece of it is frankly not relevant to you. Now, of course, it might be applicable to, say, a US parent or a non-EU parent of your organization, which might mean that they could potentially rejig things so as to ensure that the trading activities on a European exchange, whether high frequency, whether market making, whether using an algo, whether having DEA, if it's done from outside the EU, it might potentially be excluded from registration requirements. So in the UK, we've got the overseas persons exclusion, which says that a person that does not otherwise have a place of business or a presence in the UK, which is trading with or through a regulated firm in Europe, and that would include the exchanges and the trading venues themselves, then you don't need to be authorized. In the Netherlands, they have something that's very similar, and the Dutch AFM has, as I say, it's broadly the same, although it's limited to only a few jurisdictions, fundamentally including the USA and Australia, and you have to apply for it. In the UK, it's self-executing. You don't have to apply for it. If you fit within it, it's yours. In the Netherlands, you must request it. Now, we've referenced there Eurex and Germany in a question mark because Germany, just a couple of months back, the German government implemented a change to their trading rules, the law that's applicable in this space, which says that if a firm is from a jurisdiction outside the EU, whose regulatory structure is such that that jurisdiction can be deemed of equivalence under the MiFID II third country rules, then you can file an application with BaFin, the German regulator, which effectively sits on the shelf until such time as the relevant third country jurisdiction is deemed of equivalence. And in the interim, you basically buy yourselves a breathing space whereby you would stay exempt. You don't have to register in Germany or elsewhere in the EU. And Eurex is the key jurisdiction there that's relevant. Key trading venue that's relevant in that jurisdiction. Clearly, a lot of US prop traders have membership of Eurex, and Eurex was very concerned that if Germany didn't put something in place, then those members of Eurex who are outside the EU would either have to cease to be members or otherwise get catapulted into the MiFID II registration requirements. There's a significant number of those firms who have not focused on getting registered, which is why the Germans have this sort of time-limited exclusion that might work. We don't yet know the full detail. It's an evolving space, but it's something that certainly we've been very focused on with our clients. And again, this is only for non-EU persons. If you're already in the EU, this wouldn't be available in any event. The reference there to Euronext is, again, it's a jurisdiction, a trading venue of relevance to prop trading firms. So Euronext there, Paris, Lisbon, Amsterdam. Obviously, as we say, Amsterdam, there is a potential exclusion for third country firms, but there isn't any equivalent in Paris or Lisbon. So that's something of concern and of relevance, which would require authorization. But moving on to clearly the key factor here, which is questioning, certainly for UK-based prop trading firms, what might happen with Brexit. As Lance said earlier, passporting is a fundamental. So if you're already in the UK, for example, and you are either already authorized under MiFID I, or you've effectively got yourself authorized under MiFID I because of the German High Frequency Trading Act from 3 years ago, or you need to get authorized right now and you're in the process and you're deep in the weeds because of MiFID II's requirements, you could get a passport so that if you have a membership of Eurex or Euronext, wherever it might be based, whether it's Paris, Amsterdam, or Lisbon, you can trade on a cross-border basis with your services passport. Or indeed, you might have an establishment passport, which means that you can open an office in another EU jurisdiction and you're still using the home jurisdiction authorization. That, of course, based on the current political situation in the UK, is all up in the air. We simply don't know where this is going. The references to hard Brexit, soft Brexit. Hard Brexit is the UK is out in a little under 18 months from now, or no, about 18 months from now, and we don't have a passport. We don't have any ability to provide cross-border services from the UK to another EU jurisdiction. Or indeed, put it into context here, a UK-based prop trading firm authorized by the FCA, which is currently a member of Eurex, for example, using its passport to do so, might not be able to trade Eurex upon Brexit, if it's the hardest of hard Brexits.
But also, interestingly, on the other side of that, Neil, firms based outside the UK who want to access UK exchanges may not be able to access UK exchanges with a hard Brexit as well.
That's right. So, for example, if you're a German firm registered with BaFin, come the date of Brexit, what if you've got a membership of ICE Futures Europe based in London, or the London Stock Exchange, or you've got DEA to the London Stock Exchange, or you're a market maker on the London Stock Exchange, or AIM, which is the junior market here in London? That's severed. You don't have the ability to continue doing that. So that's a significant question mark. Now, a soft Brexit, which is obviously the aspiration of a lot of us here in the city, is that there be some form of equivalence, because the UK would then suddenly become a third country. If the UK is a third country, well, our rules are EU rules, because we have to have MiFID II in full force and effect as of the 3rd of January. Well, it's well over a year after that that the Brexit date would be occurring. So that's an aspiration for a lot in the city, that we would have a soft Brexit. And the next bullet point down on that slide, uncertainties. The market don't like uncertainty. Everybody wants to know what is going to happen. But frankly, we just don't know. At this stage, this political football that is the UK's membership of the EU, it's being kicked around the pitch, and we just don't know yet where it's going to go, which goal it's going to end up in. So as Lance said earlier, the firms that are already established in the UK, who set up here 3 years ago in order to get a MiFID authorization so they could passport into Germany for the High Frequency Trading Act, so algorithmic firms trading on a high frequency basis, many of those firms have taken a view, you know what, we've already gone to the expense of setting up in London. We've got people who are in London, they brought their families over here from the US, you've got the works, people who are embedded here in London. Those firms are taking a wait-and-see approach, and our view is that those firms have probably got about a year before they need to seriously think about whether or not they ought to be moving to continental Europe, or at least having a affiliate, a sister firm established there, in order to ensure that the market access continues after Brexit. The firms that have not yet set up in the UK, who are new registrants under MiFID II, so US or other firms who are moving to Europe because they have to, because they've got DEA or they're a member of a European exchange, they can't necessarily use, for example, one of those exemptions under the third country rules I referenced earlier. So, for example, if a firm was a member of Euronext Paris, those firms pretty much will have to establish in the EU under the MiFID II rules. Some of them have still set up in the UK regardless of Brexit, and we've seen a good number of firms who've been putting their applications in over the last 6 weeks or so. But, and this is the obvious focus of this webinar session, is that actually others have been focused on other jurisdictions who've said, well, okay, well, Brexit means uncertainty. Brexit means, why would I set up in the UK now if it means in 18 months' time I have to move everybody out? So that's why...
move some people out.
Well, this is it. You might have to move some or all, depending on the strategy and what you're doing. So that's why we've had clients who've very much focused in on Ireland and the Netherlands. The Netherlands is kind of the most interesting jurisdiction. As Lance said, if you think of this as a race, at one point it looked like it was head and head between Ireland and the Netherlands, but the Netherlands has actually been winning out. And we'll just brief you guys here on why the Netherlands is so appealing.
Yeah, well, I think one of the reasons of the appeal of the Netherlands is actually, quite frankly, AFM, their familiarity with proprietary trading firms. There are already large, established institutional proprietary trading firms based in the Netherlands, and the AFM is familiar with them. And so having a regulator with familiarity with proprietary trading firms, as well as with sophistication and regulation, is important, because as many that are attending this webinar understand, most regulators don't understand what a proprietary trading firm is. They start looking for customers. They start looking for investors, thinking you're a hedge fund. And so there are fundamental differences between a hedge fund and a proprietary trading firm, not just from a trading perspective, but really from a regulatory perspective. And the AFM understands proprietary trading firms. And quite frankly, based on our interactions with them, and we have met with them a number of times, they actually appear to be welcoming to proprietary trading firms and want to regulate them. And so that was a major positive as a starting point. From a prudential regime, Neil, maybe we can give a sense of what we've seen there, although maybe not as good as what we've seen from the FCA, still very reasonable.
Yeah, I mean, the Dutch prudential regime, so the regulatory capital requirements, not as favorable as the UK, where the way it works here, the FCA takes a view that firms which are conducting only on-exchange trading activities can have a very reduced regulatory capital requirement on the basis that, you know, the exchanges have their own reg capital, and indeed if you're trading through another member, so the DEA, or your trading is centrally cleared and guaranteed by another member of the exchange, you can be very flexible. The Netherlands, we're tending to see that it's somewhere in the region of 730,000 euros. That's sort of the threshold.
Right.
And certainly the clients we've been working with to establish in the Netherlands, that's been their capital requirement.
Yeah, I think the concern with other jurisdictions is, you know, we feel like from the AFM we've gotten good assurance that will be the requirement. We have not received the same assurance from other jurisdictions. So other jurisdictions may be looking at gold plating their capital requirements with an unknown number at this point, which of course, with leading up to almost 6 months, or I guess just about a little less than 6 months to the effectiveness of MiFID II, without understanding what your capital requirements, that's obviously an uncertainty that our clients just, you know, have a hard time getting their arms around. The other, and maybe equally or possibly more important issue, was the remuneration requirement.
Yes, indeed.
And I'll let Neil maybe give you a sense of, again, the view there compared to the UK as well.
Yeah, I mean, the Dutch take okay, let's take a step back, sorry. So under the capital requirements regulation, regulated firms in the EU, investment firms and banks and the like, are required to have a cap of 2 times base compensation, so 2 times salary. That's the cap on bonuses. Now, these rules come from the banking structure, but the UK has effectively switched off most of these and does not have a bonus cap for investment firms. Other jurisdictions, well, yeah, that's questionable, because a lot of jurisdictions have taken the view that that structure is good for the market, it's good for investors, and so on. But of course, prop trading firms don't have investors. And so the Dutch regulator has taken a view that actually there shouldn't be a restriction on remuneration for prop trading firms in the Netherlands. And that is a great appeal for a lot of firms who are moving to Europe. Certainly if you think of a US prop trading firm, nobody dictates how they pay their staff other than their internal structure.
Yeah, nor would 2 times bonus be all that attractive to most proprietary traders.
Indeed.
The problem is that the other jurisdictions that we have looked at, and some of the regulators we've spoken to, are not yet ready to declare that the remuneration rules do not apply. So again, you have the uncertainty of gold-plated capital requirements with the uncertainty of remuneration applying in these other jurisdictions, and that's really where we've seen most firms looking at the Netherlands as a likely jurisdiction. The other positive to Netherlands is, although their corporate tax rate, which Sanjay will get into in a little bit, seems to be, you know, it's higher than Ireland and some others. Actually, on an individual basis, for people that are 150 miles outside of the Netherlands, and most of we've done the calculation. London applies. Actually, will have a 30% of the tax will be 0 rated.
Yeah.
So we'll get to that in a bit, but that coupled with the certainty of the regulatory environment, as well as obviously people believe highly skilled workforce, good infrastructure in Amsterdam, has really led to most firms that have chosen not to register in the UK to choose the Netherlands.
So if we think about the typical structure, this is how we structure things in the UK for a prop trading structure. So there'll be a UK, typically an LLP, which would be the entity that does get authorized under MiFID II, or indeed is already authorized under MiFID I. And then there'll be a affiliate, a sister company, which takes what we consider to be the night watchman role. Certainly for an algorithmic trading firm, you would have somebody in London who's overseeing the book, just to make sure the algo doesn't go haywire, there's no flash crash. And because those activities conducted in the unregulated affiliate are conducted on an intra-group basis, so services being provided exclusively to a sister company, there's actually an exemption under MiFID I and MiFID II, which means that that entity, even though it would technically be doing a regulated activity that would need authorization or registration, it can stay exempt. Now that structure, we understand from our friends in Amsterdam that we've been working with over the course of the past year, that can easily be replicated in the Netherlands. So it's an EU regulatory structure. It's sat there, plain view in the MiFID I and MiFID II regulations. So it applies across the board, and the Dutch now take this on board. So you can use a private Dutch company, so a limited liability company, a BV. So again, you've got a trading entity, which will be regulated, and then an unregulated company. So this is a typical structure. It's straightforward in the UK to put in place. We've now learned it's straightforward to put in place as well in the Netherlands. So that side of things, the regulatory structure, straightforward, but of course regulations usually is only half of the equation when considering where to establish, and the other half of the setup is tax. So I shall hand over to Sanjay.
Thanks, Neil. So I'll give some high-level comments about the tax treatment of the entity and key individuals from a UK perspective, and then we'll come on to give us a comparative analysis, if you like, with the Dutch alternative. So the first question is, as I think the guys have mentioned, is the entity type. So you're going to pay 19% corporate tax on UK profit, and that's coming down to 17% by 2020, and that's a commitment made by the Treasury, by the UK government. It's possible, and there's been speculation that rate may come down further, but I think the prudent position is to assume that we're looking at a lowest rate of being 17%. So how you get to that 17% will vary depending on the entity type that you establish. If you have a UK private limited company, it's a ring-fenced entity, and all the profits minus amounts that you deduct, you're allowed to deduct for tax purposes, are taxable in that entity, and nobody else effectively gets taxed in your group structure. If you establish a UK limited liability partnership, a UK LLP, that is effectively you get to the same answer, but instead of the entity being taxed as a corporate, the partners are taxed. And without going into the detail, we think that there are some benefits to utilising an LLP as opposed to a UK company, but it depends on your group structure and the sort of wider preferences of your particular organisation. So a couple of points come out of the sort of entity level and relate to your group structure. Firstly, you obviously need to think about whether you have a separate taxable entity like a UK company, or you've got a UK permanent establishment, so a taxable presence of another entity in the UK, and you have a slightly different taxing profile. Allied with that, you have transfer pricing considerations to think about. So, for example, if you have code or alpha or value being generated outside the UK, in Germany or France or the United States or anywhere else, and it's supplied to or being deemed to be provided to the UK entity so that the UK entity can trade and carry out its business, you need to work out what an arm's length value would be for that, for those services being provided. So effectively you have a transfer pricing analysis to contend with. And through our experience, we have what we think is an established methodology, working with accountants and other advisors and clients closely, and putting in place what we think is a robust analysis for those entities, those group structures, so that they are lower risk in the eyes of the taxing authorities. Finally, on the group structure, if you have supplies being made to the UK entity, because of the nature of the financial services business being carried out by a proprietary trading firm, it cannot recover its input VAT. So when it has to pay VAT, or is treated as paying VAT on any services that it receives, it's an absolute cost. So everybody focuses on the corporate tax rate that I mentioned, but what's often overlooked, and through our experience we've been able to work with clients to illuminate some of these issues, is VAT. So if you suffer a VAT cost, it's an absolute cost of 20%. And if you have, as I said before, an algorithm or code or value somehow being generated outside the UK and being treated by the taxing authorities as provided to the UK entity so it can trade, the UK entity has a potential tax leakage of 20% of whatever the value of that service is. So again, without going into detail, it's something that we've worked closely with clients in order to structure things so that we can manage that risk, and where we believe we've got to a pretty robust position. Finally, at the sort of compensation level, so for individuals, there are a number of issues to think about, but as I'm sure everyone on the call will be familiar, some people want to come into the business as a partner, and obviously that's much more possible for tax purposes if you have a UK LLP. Others will be correctly designated as employees, and yet there's a third category of consultants, which obviously means that individuals are working as an independent contractor and they're self-employed. So there can be tax advantages from any of those different ways in which you provide services to the business. So on the Dutch side, just I'll give some high-level comments about this, just so that you can kind of understand where we've seen benefits. At the corporate tax rate, you're looking at 25% with a 20% first step on the first €200 of profit, but in effect you're looking at a blended rate in the sort of low to mid-20s. And obviously, if you look across the EU, that's a pretty favourable tax rate. So at an entity level, that makes sense. And just to stop there and to pick up something that Neil said, from an overall sort of corporate tax perspective, we think we can get to the same or very similar position to the UK in terms of structuring, but in terms of the point of detail, they don't have the same UK equivalent of an LLP. So we established there a ring-fenced entity, but as I said before, with the UK, you get to the same position, but through a slightly different mechanic. A couple of other points on the corporate tax sort of group structuring level. The Netherlands, like the UK, benefits from a very favourable double tax treaty network. So what that means is, if your entity needs funding or you need to get amounts out of that entity, again, whether it's in another EU jurisdiction or in the US, you should be able to get what is a headline dividend withholding tax rate of 15% down to 0%. And if it's not zero, it's going to be, it may, for example, be 5%, but you can structure things so that the dividend is not a material drag. Again, on the interest withholding and royalty payments, there's zero withholding. So like one or two other jurisdictions, the Netherlands just doesn't impose withholding on those amounts. So that's great. You don't actually need to deal with that. And then in terms of VAT, again, the group structure, you encounter the same or very similar issues in the Netherlands as we have done in the UK, and we found that we are through a number of years of experience with dealing with taxing authorities and clients in this space, we've got to what we think is a pretty robust position in terms of structuring. I'll just, as Lance said, again, there's a point which often gets overlooked, a couple of points on compensation, which make the Netherlands particularly attractive. Firstly, there's a specific tax regime for expats, and as Lance said, there is a point of detail here where you need to be somebody who's effectively domiciled, resident-based, at least 150. I'll just make one.
Yeah, it was kilometers, not miles.
Yeah, sorry.
I'm sorry, that's American and correct.
EU, another point of difference between EU and the UK is their, let's say, their obsession with the metric system and our similar obsession with the imperial system. So 150 kilometers, but I'm assuming no one is in that sliver of land that is between 150 kilometers and 150 miles. But the big benefit that delivers is 30% of your salary and bonus and stock options, if relevant, are tax-free in terms of income tax. So that allows some pretty competitive compensation structuring. There are further points of detail. For example, when clients get excited about being able to utilize this regime, but at the same time wanting to set up in a hurry, you need to make sure that, for example, individuals that want to benefit from this don't, for example, go and buy a property or rent a property or do something that effectively means they are disallowed, that they're excluded from being regarded as expats, which again, we go through carefully with clients. So one final point on compensation. Most EU jurisdictions, or many of them, have uncapped social security or national insurance contributions. And when everyone is looking at corporate tax rates and in fact also personal income tax rates, again, they often overlook this point, and you can find that social security contributions layer up or even double the income tax burden. So you can have social security contributions in the high 20s and they're uncapped, which is punitive. So in the Netherlands, you have quite a moderate cap on the national insurance contributions. So you have certainty. I think, as Lance says, a big point here in choosing a jurisdiction is having certainty, not just on the regulatory regime, but on the tax side. So there are a range of points to take into account, but the big message is that the Netherlands is manageable and pretty low risk and stable for tax purposes.
Yeah, I guess on in a little bit of detail, the U.S. foreign tax credit for this audience is probably more limited, but a lot of what we'll deal with and what the structuring deals with is to be as tax efficient as possible. So obviously, depending on whether you're located in the U.S. Or in the U.K. or on the continent, being tax efficient is important. And so our structures do take into account that tax efficiency as well as regulatory efficiency. In particular, once you figure out, if you're based in the U.S. and you have operations in the U.S., outside the U.S., you will need to figure out how those foreign taxes, whether in the U.K., the Netherlands, Ireland, or otherwise, actually transfer over into U.S. taxes. Now, it actually doesn't work as neat as everybody would believe, that if I pay $100 tax in the U.K. and I'm a U.S. partnership, I get a $100 credit, and therefore, actually, it looks like it's a good thing to be trading or to have UK tax, since the UK tax is lower than the US corporate tax. The problem is that it doesn't actually work dollar for dollar. There's material slippage there, and if you're trading certain products like futures and others, which may have, at least in the US, beneficial tax treatment, the slippage becomes even greater. So one of the pieces of the puzzle in figuring out not only the local tax is how that credits back to the US and other jurisdictions. So I think with that, I would say one of the things we've looked at in the Netherlands, and again, the Netherlands, we actually don't have people on the ground in the Netherlands. So this has really been a review of the Netherlands on the basis of its merits compared to the other countries, and it seems to be the best alternative There are some things on this slide that I'll show you. In order to set up a Dutch company, there are some things, including the licensing, where you will have to have at least 2 directors living in the Netherlands. However, they do not need to be Dutch nationals, so they can be UK nationals or otherwise. They will test them on their trustworthiness and suitability and put them through a review process, although I'm not sure that's all that dissimilar to the FCA. Is that correct, Neil?
That's right, Lance. Yeah, I mean, certainly, given that the structure of the licensing requirements and the arrangements in the Netherlands are based on European directives, just as the UK rules are currently, if Brexit means that there is no passporting and you're currently a UK-based prop trading firm and you do think, okay, well, we have to establish something in Amsterdam in order to continue our activities post-Brexit, yeah, you're going to need at least 2 people who are actually physically living in the Netherlands. As we said, if they're moving from over 150 kilometers away, there's a great tax break for those individuals. Curiously, I think the very southeast of Kent is within the 150 kilometer boundary, but certainly somebody based in London currently would be able to move to Amsterdam, for example, and get that tax break. But certainly, yeah, the structure in terms of trustworthiness and suitability tests, the Dutch AFMs, the Dutch regulator systems and controls requirements, the tests as to the financial solidity of shareholders. These are all very, very familiar to us in the sense that going through all of this with the FCA over recent years, the Dutch rules are basically the same. Some of the phraseology is slightly different, but if you're already registered under MiFID I here, this will not be a big change. It won't be a big surprise. What will be slightly different is the regulatory structure in the Netherlands, the AFM, which is the equivalent of the FCA, and then the DCB, the Dutch Central Bank. Both of them take responsibility. Slightly different from the UK structure with the Prudential Regulation Authority, PRA, and the FCA. They both focus in on the regulated sector. Certainly the central bank is focused particularly on the solvency and capital requirements. And as we referenced earlier, there is no bonus cap or a particular remuneration limit in the Netherlands for a prop trading firm. So if you're a UK-based firm and you're going to be moving to continental Europe as a result of Brexit, and as we said earlier, we don't know quite yet where this is going to shake out. We don't quite know how and when the timing is going to be just right to make those sorts of determinations. It should be a watching brief for now, we would recommend. But as Brexit develops and the negotiations become clearer, we do think that, yeah, the Amsterdam option or the Dutch alternative, as we phrased it, would certainly be a fair option for the proprietary trading community. And one thing that we have thought about is whether there might be a 3-country workaround for these rules. Now, rather curiously, when we put these slides together, it was before ESMA put out its opinion, which was some 4 weeks ago now, saying that you cannot get access to European markets as a UK firm by simply establishing a, quote, letterbox entity in continental Europe. You can't just have a branch or an office established somewhere in Europe, say Amsterdam or Dublin, and then outsource everything from that regulated office straight back to the UK so that you keep all your stuff in the UK. That's not going to wash. So what ESMA was saying is that if you want to be able to use these passport rights and have a branch establishment, if you're going to try and arbitrage these rules, you do have to have sufficient substance in the MiFID II office regulated in continental Europe in order to make it work. So the 3-country workaround would only work if there's actually sufficient substance of actual trading activities taking place in the other office, say the Amsterdam office. So you can't entirely arbitrage outside the EU rules. You couldn't keep everybody in London and just, shall we say, fudge the issue. So while this is a developing area still, it's certainly something that the European regulators are very focused on in making sure that Brexit isn't hedged around and people work around the outside of the rules. Let's say that at this stage, it's pretty clear that's not going to work, but it may still be possible to maintain an office in London as well as an office in continental Europe so that while there might end up being 2 European offices, one in the EU, one in London, that's still some way to go before we've got a final picture.
And I think, I mean, it may be possible, and we've had clients explore that are already on the continent, but they're in a jurisdiction right now that potentially is gold plating and or apply remuneration controls. And so those clients have looked at potentially establishing the actual regulated entity in the Netherlands or another country, and then effectively relying on an intergroup exemption to continue to have people on the ground in the other countries. But as Neil said, it's important that there's sufficient substance on the ground in the regulated entity, and that sufficiency of that substance will often be, quite frankly, a conversation, negotiation with the local regulator. We think we will also see the same issue raise its head when Brexit is final, because as we mentioned earlier, you still will need to figure out how to get back into the UK on a regulated basis if you were to determine to move all of your regulated entities outside of the UK onto the continent. So still a developing area. What we haven't touched on, there's a lot of, besides tax and regulatory, there's corporate, there's immigration, there's employment, there's intellectual property issues that all need to be sorted, as well as trading capital efficiency. I think one of the biggest issues we've seen is having to now potentially split the books between one jurisdiction and another jurisdiction, because, for instance, if you need to trade on U.S. markets, you have it in a non-regulated entity, but today you were trading on Eurex in the same book as the U.S. with offsetting positions and capital efficiency. Well, now you need to take half that book and put it in a UK regulated company with its own capital requirements while still maintaining the rest of the book outside. Those are the type of issues that still will need to be solved, because obviously, besides actual regulatory capital efficiency, what's of utmost importance to our client is margin capital efficiency, and that's still being sorted. So with that, I think we'd like to join everybody, or thank everybody for joining us today. We know that we gave a lot of information at a very high level. We through Rob can be available for further conversations if people want to drill down into any specific areas or any specific questions about various jurisdictions. But I'll turn it over to Rob now for conclusion.
Yeah, so it doesn't look like we've had any questions come in currently. But again, as I said, you can reach out to us through the website. The webinar will be available to rewatch, and we can get in touch with Lance, Sanjay, or Neil if you'd like to set up a meeting. Sound good?
All right, thank you.
Thank you.
All right, guys. Thanks again for your time, and
Okay. Have a good day. Thank you.
Thanks, guys.
Bye-bye.
Bye.